Okay. Good morning. I'd like to welcome everyone to the 29th meeting in 2012 of the Local Government and Regeneration Committee. As usual, can I ask everyone to ensure that they have switched off mobile phones and all other electronic devices, please. I've received apologies from John Pentland for the meeting. We're joined by his committee substitute for this meeting, Dr. Richard Simpson. Welcome, Richard. Do you have any declarations you'd like to make?
Yes, apart from drawing attention to my written declaration, I should declare that my wife is a councillor.
Thank you very much for that. Agenda item 1. The first item of business today is to consider whether to take agenda item 5 on consideration of the evidence we took on Scottish local elections in private. Are we all agreed? Thank you very much. We move on to agenda item 2, which is an oral evidence-taking session on the High Hedges Scotland Bill. This is the second of 3 evidence-taking sessions which we are holding this month as part of our examination of the bill. We have 2 panels of witnesses today. Before we move to witnesses, I'd like to welcome the member in charge of the bill, Mark MacDonald. Welcome, Mark. Our first panel are joining us live from Douglas in the Isle of Man via video conference link and represent the Manx Government and the local authority in Braddon. Can I begin by asking our witnesses in Douglas to introduce themselves for the record and confirm they can hear and see us? Gentlemen, please.
Good morning, Scotland. We can hear you loud and clear. My name is Roy Corlett. I'm the Legislation Manager at the Department of Infrastructure on the Isle of Man.
My name is Peter Keenan, Southern Area Forester with the Department of Environment, Food and Agriculture, Forestry Directorate.
Good morning. My name is Colin Whiteway. I'm Clerk to Braddon Parish Commissioners, which is one of the larger of the 24 local authorities on the island.
Good morning, Scotland. My name is Paul Parker, and I am the Community Warden for Braddon Parish Commissioners and deal with enforcement.
Thank you, gentlemen. As I said to you before we went live, I'm Kevin Stewart. I'm the convener of the committee here. I'll ask the first question, and then we will ask members to give their names, and then they will ask questions as we go along. Can I start off, gentlemen, by asking you your views of the statutory definition of a hedge as set out in Section 1 of the bill, please?
Well, from an Isle of Man perspective, we are aware of the proposals that Scotland are looking to introduce and recognise that the proposals are very similar to what is already in operation in England and Wales. But we were conscious that the Isle of Man legislation does contain what is being proposed in Scotland and what is already in operation in England. And that is why I think we've been asked to provide evidence today. So I'm sure we'll go on to explain in more detail as we progress the meeting as to our views on the definition side of the proposed legislation in Scotland. But our view today would be to try and emphasise how we're experiencing the introduction of the legislation from an Isle of Man perspective.
Okay, gentlemen, obviously your legislation is somewhat different. Have you had any difficulties in terms of the legislation that you have put in place?
I think we've only had a few days to discuss the issue with some of the larger enforcing authorities on the Isle of Man. It might be helpful if I explain that on the Isle of Man we have 9 government departments and we have 2 representatives from those government departments here today, myself from the Department of Infrastructure and my colleague Peter Keenan from the Department of Environment, Food and Agriculture. The Department of Infrastructure has a responsibility for overseeing local authorities on the Isle of Man and is involved in any legislation which has a potential impact on local authorities. But it also might be helpful if I pointed out to the committee that the Isle of Man has 24 local authorities. So it hasn't been possible in the short time we've had available to consult with all those local authorities. So all we've tried to do is concentrate on obtaining views from a few of the people involved. So we have to recognise that the answers that we're giving today are, to a certain extent, a little bit limited because we haven't had a full chance to consult. But having said that, I think the general view is that we've had a few difficulties with enforcing the legislation, but nothing that has proved unsurmountable. And we've been able to rely on the guidance which has been available for England from the British Research Establishment. But we've had to bear in mind that that has also needed to be slightly adjusted to take account of the differences in the definition of high hedge and the fact that we also include single trees. I don't know whether my colleague might do.
Thank you for that. I'm going to bring in my colleague Margaret Mitchell, who has a specific question round about your legislation.
Good morning, gentlemen. This question may well be directed at Colin and Paul. We're currently looking at the legislation before us and deciding whether it should be extended to include trees and deciduous hedges. And we're aware of the recent appeal court case in the Isle of Man, Boardman versus the Brandon Commissioners. I wonder, could you outline for the committee the background to this recent appeal case and whether that has led to any similar appeals?
I can briefly explain. The complaint was submitted to the authority and the community warden was asked to deal with the matter. He was asked to deal with the matter once he was confident that there was sufficient mediation between both parties. And I'll pass on to Paul, who will explain what happened then.
Good morning. Basically, the Act requires for all other avenues to be exhausted prior to any case being taken on board by the local authority and being reviewed. What's happened is we received the initial inquiry on the 25th of January 2011 from the complainant, Mr. Boardman, and we then explained the situation to him. He then went back and discussed the issues that he had with the hedge owner, which then led to a formal complaint being submitted on the 22nd of May. On this occasion, the complainant could actually evidence that it exhausted all other avenues by showing us correspondence, records of telephone conversations, etc. That was perfect. Then we could see then that there was an issue, and it wasn't going to be resolved between the two parties. So we took the case on board from that point. On the 24th of May, we then carried out site visits. First, going to the complainant and establishing his side of the story and the views. That way we got a visual on the issue, the hedging question and its makeup and how it was affecting the property as a whole. We then went to the complainant, to the hedge owner, and we got their views as to why the hedge was planted or when it was established. And from there on, we carried out the investigation. That investigation consisted of many field trips to both properties, to the gardens, and internal inspections at different varying times of the day and different months. The beneficial thing in relation to the Act is we have no time constraints from the initial complaint being made to the resolution point. So that allows us to actually view the alleged effects, whether they are adverse seasonally or it's going to be going on for a long period, basically. It gives us a chance to see it in each growing period. So with full leaf, when it's lost its leaf, if it's deciduous, and it gives us an idea of what the growth rate is for the non-deciduous and deciduous plants and shrubs that we were investigating that made up part of the hedges. This then went on for a number of months with visits going backwards and forwards through June, July. We kept records from the Met Office in relation to the weather conditions, because obviously you can get complaints that they're shading lawns and causing issues to lawns and many other areas of the garden. All that said and done, this case, the initial case we're talking about now, which was Boardman versus Brandon Commissioners, did go on for quite some time. And it was the 14th of September 2011 before we actually had a date from the courts for a directions hearing, and it wasn't until the June the following year that we actually got that case in court. So it's good not to have the time constraints, but it does unfortunately go on for a long time. It's a lengthy period and can be time and cost consuming.
It would be helpful if you could maybe give some details about what the hedge owner was saying and what the complainant was saying. What was the issue? Was it light? Was it something else?
The main issue was light to the garden and the property, and from the complainant. And his issue was that due to the fact that it was a continuous barrier to light, allegedly, then the issue was affecting his lower rooms, the ground floor rooms in his domestic dwelling, mainly the living area and the kitchen area, which were at the rear of the property. Upon investigation, we found that it was an issue, but not to the extent. So it did have a reverse effect on part of the house, but not the whole house. Therefore, it became quite a complex case. And with the makeup of the bank being the boundary between the two properties was actually a 2 metre high bank on the complainant's side, and the hedge line started at the centre of that bank, and it dropped on the owner's side to between 2 and 3 metres in depth. Now, the hedge owner said that he established this hedge and it had been professionally planted, so they had kind of picked hedges that were suitable, although there were a couple of deciduous trees in there that maybe weren't suitable and will have a growth rate that would cause issues in the coming years. But the hedge owner decided that it was done so for privacy reasons, because the complainant owners and his upper floor windows from the complainant's property look straight into the bedroom windows of the hedge owner's property. Therefore, we had to take into account the privacy issues that would be caused if everything was cut down to an actual hedge height. The view was that we could gain more light to the complainant by placing strategically placed gaps, significant gaps within the hedge of heights above 2 metres, allowing for an extended growth area of the deciduous trees and some of the deciduous shrubs. This caused light to come through and kept the privacy for the hedge owner.
Thank you very much. That's very helpful.
I'm going to bring in my colleague Anne McTaggart now. Anne?
Good morning, and good morning, panel. My question's around fees, and there is evidence to suggest that there is no upper limit or cap applied to the fees in the Isle of Man. Could you give me an indication of the average fee for a single application?
Yes, I should be pleased to assist with the answer. The fees on the Isle of Man are set at a figure of £150, and they have been set at that figure for several years now. But there is discretion within the fees to allow for a refund if there is, depending on what stage after the complaint, the matter might end up with being dealt with after the first remedial letter is issued or after a visit is made to the site. So the department was trying to encourage the two parties to continue talking and to try and encourage a mediation process, even though the fee hadn't initially been paid by the complainant.
Thank you. Has the fact that there is no upper limit or cap on application fees in your jurisdiction proven to be prohibitive for those experiencing problems with nuisance vegetation?
I think that's maybe an issue that the department will be looking to gain views from all the local authorities. We've only had a very limited number of cases where an amount of a fee has actually been paid. But I think the department, when they originally set the fee, was wanting to set a figure which was not too cost prohibitive, and so wanted to encourage people to make use of the applicable legislation But at the same time, I think that in the light of experience, the Department may wish to consider the current level of fees that are in place.
Thank you.
Thank you for that, gentlemen. And can I take you back to Boardman versus the Braddon Commissioners? Because obviously that sounds quite a complex case, and I'm quite sure that that will have cost quite a bit of money. Who has been picking up the tab for that case?
The local authority picked up the money for the case. We had to present the case, and because it was so important, we had to instruct an advocate. By the end of the case, we'd actually spent over £7,500 on the matter. We think the complainant had spent considerably more than that. It was adjudicated by the High Bailiff, and we were to meet our own costs. So, yes, in the end, £7,500 of the local authority's money was spent on that.
Okay, I think it would be very interesting for our committee here to get an indication, a comprehensive figure of how much that actually cost in terms of dealing with our deliberations here. If that's possible, I'd be grateful, gentlemen, if that could be emailed to the clerks here. I'm going to bring in my colleague John Wilson now.
Good morning. It's on the fees issue. We've just heard the figure of £7,500. Just to try and clarify, was that the £7,500 was the cost of actually taking the case to the Commissioner, or was that all the fees, including the site visits that were carried out by the staff to monitor the growth and the barrier to light?
Well, we haven't actually calculated the cost in staff hours, staff time. The £7,500 is related to our legal expenses paid to our advocate. The amount of time was extraordinary. It would be in many thousands of pounds, I'm sure. We could probably calculate it for you and come back to you on that. But £7,500 was purely to our advocate.
Right, thank you, Colin. It's just that Paul had mentioned earlier in the evidence session that there were a number of site visits throughout what I would assume was the growing season. It was almost 12 months if you monitor the 4 seasons in terms of barrier to light, and it's the cost to the local authority in relation to the 12-month monitoring of any development and any barrier to light or growth issues that may accrue before you actually decide to take action on the property.
Yes, again, we'd have to calculate that, but Paul spent a large amount of time on the task, on regular visits to both sites. We can probably work something out on that one.
Clarify whether or not specialist equipment was used by the staff when they were monitoring the barrier to light and other issues?
I think the most advanced was a pole that was 6 metres high. There was no specialist equipment at all.
Hey, thank you for that. Thank you, Jim.
I'm going to bring in my colleague Stuart McMillan now, gentlemen. Stuart.
Good morning, gentlemen. It's I've got a question regarding just the legislation that you have in the Isle of Man and the legislation that was passed at Westminster. In terms of the public perception in the Isle of Man of the legislation, with what has been passed on the Isle of Man, is that deemed to be popular with the population, or has there been any kind of campaign suggesting that it's overly cumbersome and there's too much of a burden that's been placed upon the population of the Isle of Man as compared to the legislation that has been passed at Westminster?
Well, from the department's point of view, we feel that the legislation seems to have worked well on the Isle of Man. I think the majority of people are able to access the information. They're able to mediate amongst themselves, the complainant and the hedge owner, and the department wouldn't necessarily hear much more about a particular case, apart from perhaps a phone call, and then they're advised to look at the website and they do their own work on their website and research the issue and work out whether they have a case that they can take forward. I think the legislation has gone down well on the Isle of Man, and it seems to have certainly settled a lot of cases that previously would have caused issues. But I'm sure my colleagues would like to expand on individual cases which might be helpful to your committee.
Yes, I think there are quite a number of complaints, probably 6, 7 a year. And this, the only time we've actually been into court and it's got this far, but this is the only case, a landmark case. So in general, the legislation has worked very well.
What we've found is...
Again, did you say 6 or 7 cases a year?
Yes, relating to our own, we're only one of the authorities, but 6 or 7 a year, yes.
So that's for Braddon only?
It's only Braddon, yes. I think there are a couple of larger authorities. We haven't got the figures for those here. I think we're going to do some work on that. But 6 for us, certainly.
Thank you. Stuart McMillan.
Certainly, thank you. I think it would be very useful, certainly for our deliberations here, if once you actually have undertaken your further work in terms of the 24 authorities, if that information could be sent over to us, just to provide us with a wider context as to how much that the legislation actually has been used, if that's possible.
Yes, we'd be more than happy to assist the committee, and I'm sure we can work out a figure from all the Ireland's 24 local authorities which would pinpoint the information you require.
That'd be great. Also, see with that information, would it be possible to have that kind of broken down in terms of the types of the types of dispute, i.e., are there disputes regarding hedges or are they regarding trees, and also kind of what the subjects of the applications are? Would that be possible as well?
Yes, by all means, we'll try and break down the information as to whatever format is most helpful to you.
That'd be very helpful. Thank you.
I'll bring in my colleague Richard Simpson now, gentlemen.
Could I just ask a supplementary on that? Would it be possible to indicate whether they were not just single trees and hedges, but whether they were deciduous or non-deciduous, evergreen, if that's possible? I know you don't treat them differently in the Isle of Man, but if it's possible. And also, at what stage in the process the dispute was resolved? Because from what I hear, from what you're saying this morning, it would appear that a lot of the stuff has been actually resolved because there is a website, there is information, and because it's got the legal underpinning, people are more prepared to reach an agreement, because otherwise it'll have to go forward to a more complex approach. So it would be useful to know how many of the cases appear to have been resolved at a pretty early stage.
Yes, again, we'll do what we can to assist.
That's most appreciated. In terms of the single tree and deciduous situation, we've had some evidence here that there would have to be safeguards built in for wildlife and for biodiversity. In terms of the legislation that you have, are those safeguards in place? Have there been any difficulties round about that aspect of legislation?
I think it might be helpful if I pinpoint the Tree and High Hedges Act on the Isle of Man. Actually includes a specific section, section 4.b, which requires the enforcing authority to consult with the Department of Environment, Food and Agriculture to the extent to which any tree contributes to the amenity of the neighbourhood. So in other words, what we're saying is on the Isle of Man, the enforcing authority is obliged to consult with to seek professional advice to the people from the Forestry Division, and I'm sure my colleague Peter Keenan will be able to assist to provide further details on that point.
Yes, all trees are assessed individually on an individual basis for biodiversity and amenity value. So we look at that and take on board any questions or queries that are raised.
Okay, thank you. We have with us today Mark MacDonald, who is the proposer of the bill here. I'm going to ask Mark if he would like to ask you some questions now. Mark.
Yes, thank you very much, Convener, and good morning, gentlemen. The only question I have, really, because most of the issues I think have been teased out, is just a supplementary to that question in relation to biodiversity and amenity impact. Has there been a requirement for local authorities to bring in external consultancy or external expertise on that, or is it all dealt with by central government department?
Well, I can confirm that it is dealt with all through government departments, with the local authorities and the Department of Infrastructure working with the Department of Food, Environment and Agriculture. Peter will maybe, if he could explain what qualifications the forestry officers have there just to clarify further for the committee.
All foresters are trained to a degree level, and we do have a trained arborist within the department as well, and that includes wildlife officers also. So we have the whole team there that can be drawn upon to give their views on any issues that may be raised.
And just in discussions I had before bringing forward the legislation, one of the points that was brought forward quite strongly, certainly from local authority perspective, was the need for an element of cost neutrality within the legislation. It would appear from the evidence you're giving that there is not quite the level of cost neutrality in the Isle of Man case, insofar as the fees charged do not cover the costs incurred. In cases where, for example, government advice is required in relation to biodiversity and amenity, are those costs factored into the local authorities' costs in relation to the case, or are they factored into central government costs? And I wonder if it might be possible for those to be provided as well.
Well, at the moment, the costs are covered by central government, but the issue of review of the fees is probably something that the department will look to undertake in the near future in the light of experience.
And just one...
Certainly,
sorry.
Yeah, certainly the fees don't cover our costs, but that is part of our function anyway. It's something we need to absorb. It's part of our function as a local authority.
And just one final question. You mentioned for Braddon Parish there were around 6 cases per annum as a result of the legislation. Just to perhaps put that into some form of context, would you be able to tell us what the population of Braddon Parish is?
There's just over 2,000 registered voters in the parish, but the parish is quite a large rate income producer because it has a lot of businesses in the parish.
Okay, thank you.
I'm going to take Stuart McMillan back in, gentlemen. Stuart.
Thank you. Just taking one final question from myself. It's in terms of your legislation, that's been in operation now since 2005. Are there any parts of the legislation that you feel could be amended or adjusted to actually make things work smoother and better? Or do you think that the legislation that you have is actually the best that it possibly can be?
I think the department may wish to consult on that issue, or it may be that some local authorities may wish to draw issues with the legislation to the department's attention. But certainly the department would be prepared to review any elements of the legislation if it received a request from a local authority, and we undertake due consultation on that to seek the views of all 24 local authorities on the island, and our colleagues from the Department of Environment, Food and Agriculture as well.
Have you had any requests thus far to review the legislation?
Not at the moment, but in the light of recent developments, it's possible that might arise in the next few weeks, I suspect.
I think it would be useful, certainly for us, if that does actually take place, if we could be kept informed of that, please.
By all means, but I think the emphasis on any change that was being proposed might be along the lines of reviewing the process of the appeal process rather than the actual definitions which are currently in place. Though it might be that my colleagues can answer to help.
From a local authority point of view, it wouldn't be. It may be beneficial to look at the definition, but it wouldn't prove conclusive. I think personally, the issues that we came across and we come up against in the Borden versus Braddon Commissioner's case related to the guidelines more so, and that we may have to look at an adjustment to the guidelines, and hopefully we'll be able to discuss that with the department in the near future. It's something that's come to light since discussing it with the Scottish Government, and something that's come out of the court case, the recent court case. But the legislation itself has proven to be beneficial to include deciduous, in my opinion, as a local authority enforcement officer. Going back on that, if we went back to the averaging out on 6 cases a year since the Act came into place, what we're looking at is that 75% of those cases did include a deciduous tree of some sort, whether it be in a hedge or whether it be a row of trees or a lone tree. And out of that, 50% actually included a single deciduous tree, which was situated within 5 to 10 metres of a property. As you can imagine, if you've got a tree that within that distance that's dwarfing the property, it can block out more, if not, well, as much light, or if not more, than an evergreen hedge.
See, in terms of that final example, what was there first? Was it the tree or was it the property?
It's hard for me to say. I've not been there that long, so you would say that the tree was probably established first, and it's been inherited by the property after the property's been built. Some trees you can see have been planted, and we do have rapid growth on the island due to the mild weather conditions. You see, we get very little frost and that here, so we do get a rapid growth on some trees. Obviously, my colleague Peter...
Some locations.
Yeah, on some locations. In relation to the issues that we've dealt with, I would say it's probably 50-50. The trees were established first, and there's nothing leading the way there.
Okay, thank you.
Thank you. I'm going to bring Margaret Mitchell back in, gentlemen.
Just one final question, gentlemen. Are there tree preservation orders in the Isle of Man, and if so, how have they worked in relation to the legislation?
There's no tree preservation orders as such. What we do have is a Tree Preservation Act, which covers trees within the island, and there are areas and individual trees which are registered under this Act, and we monitor that and supervise that in part of our legislation.
And has it been affected, or have you covered the scenario that it might be affected, and which one would necessarily or otherwise take precedence?
We haven't had any cases that have really affected it, to be honest. Everything's been sorted at the initial stage. We, as an authority, as a government body, issue felling licences for trees. We're unique in a way in as much as homeowners have to apply to us for a felling licence to remove any trees on their property, which is not the case in the UK, obviously. So any of these cases that may crop up, we sort of deal with them before they get to the High Hedges Act, High Hedges side of things. So we can assess problems as and when they can come up, and a lot of them are resolved by a site visit from ourselves.
Thank you very much.
Okay. Anyone else want to come in? No. Gentlemen, can I thank you very much for agreeing to give evidence today. I'm glad that we've got through this video link without any problems. I thought I'd put the hex in the entire thing earlier, but obviously my Luddite ways were proven wrong by the technology actually working all the way through. Thank you very much indeed, gentlemen. I now
Thank you.
I now suspend the meeting for 10 minutes to allow for changes to take place. Before I begin the next item, I have been corrected by the clerks because the briefing note was a little bit wrong. In terms of item 5, which we already agreed to take in private, can we also agree to take item 3 in private too? Agreed. Thank you very much. In which case we now move on to our next panel of witnesses on the High Hedges Bill. Can I welcome Robert Patterson, Land Services Officer of Clackmannanshire Council and member of the Scottish Tree Officers Group, Eric Hamilton, Forestry Officer of Dundee City Council and Branch Treasurer of the Scottish Branch of Arboricultural Association, and Graham Phillips, Forest Manager for Bell Ingram Limited. Can I ask you the same question as I asked the panel from the Isle of Man to begin with, and that is, what is your views on the statutory definition of a hedge as set out in section 1 of the bill? Can I start with Mr Phillips, please?
Thank you. I feel reasonably comfortable with the current definition of a high hedge. I feel it's tight enough to deal with the quite specific problems that the bill appears to be wanting to address without giving too much scope for the capture of individual trees and woodland trees within that. I note a point that was raised by others here that rows of say, for example, 2 Scots pines would potentially fall under this. However, I feel that the crucial clause in the definition here is that a hedge would not be regarded as forming a barrier to light if there are gaps, which a Scots pine would almost always elude this definition through that point. However, any extra guidance within the definition that would reduce the amount that was open to interpretation, I would certainly be supportive of.
Thank you. Mr Hamilton, please.
Yes, high hedge definition, as far as we're concerned, people I've been speaking to, it must mean high hedges and not any trees of any type. It must be planted as a hedge and grown as a hedge. Once you start introducing trees into high hedges in the same bill, it will lead to tremendous problems.
Thank you. Mr Patterson.
I would agree entirely with my colleague Eric on that matter.
Okay, thank you very much. Committee? Margaret Mitchell, please. You
would have heard the last question we asked Isle of Man about tree preservation orders, and you'll also be aware that in the bill there's provision for local authorities, while having regard to the TPOs, shouldn't be constrained by them in carrying out their duty in relation to the legislation. Could I have the panel's view on that provision, starting perhaps with Mr Patterson and working in the opposite direction?
Yes, I mean the Tree Officers Group response is quite, specific insofar that we would consider that a tree or trees that are protected because they have amenity, landscape, or some value of intrinsic beauty to provide to the area that they grow in. And secondary to that is that even if 2 evergreen trees, there are very few semi-evergreen trees, with the odd exception. If they were to come under the auspices of the Act, they could be ruined in terms of appearance and physiological condition if pruning were to abate what would be termed as a nuisance under the proposed Act.
Tree preservation orders, I'm not aware of any cypress hedges or any hedges in Scotland having a tree preservation order. Tree preservation orders, it can include hedges, but it is mainly for trees. The
We're looking at the possibility of apparently or possibly extending the legislation to cover deciduous trees. So the question really was preempting your assumption that that might be the case.
I would ask you to remove tree preservation orders, any contact with tree preservation orders from this bill altogether.
I would support that view. I think if the legislation is to be kept essentially to Leylandia and similar hedges, the TPO clause would be unnecessary. And if the definition was to be broadened to single and deciduous trees, it could potentially lead to very valuable trees being damaged or lost.
So you wouldn't favour in any circumstances looking at it in the common sense basis, with the passage of time, or even as Isle of Man had looked at it. It seemed to me that they looked at the particular circumstances. They monitored, as I understood their evidence, on a regular basis from site inspections of these trees covered by the tree preservation order. And in a way, they thought they had almost preempted the problem in doing that.
I think the way to deal with that should be more as a review of TPOs themselves, rather than through this particular legislation. If for example, a tree becomes dangerous, obviously that would preclude a TPO. But I think the common sense approach, yes, is very valid, but I think it should be at the TPO stage rather than than under this legislation.
I think this is particularly relevant maybe to the other two panellists, given I'm not sure that TPOs are regularly inspected in Scotland in each local authority, but perhaps you can disabuse me of that view.
Well, you've given us a get-out clause in the TPO legislation just now, because you haven't defined how long we must take in between each review of each tree preservation order. In my authority, we're carrying out a 10-year review after 30 years of not reviewing anything.
Similarly, at Clackmannanshire Council, we haven't had the resources or indeed the time to review the existing tree preservation orders. We have produced 3 new ones within the last 5 years, but I think we have a total of about 27 tree preservation orders, most of which are area orders, which include more than a single tree. There is one tree preservation order in Clackmannanshire that is specific to a Sequoiadendron giganteum tree, which is a specimen tree in the village of Devonside. All the rest are area orders.
And given Clackmannanshire is the smallest local authority, you can imagine that the resource problem for actually would be so much worse than the larger authorities.
I would agree.
Okay.
Stuart Stevenson, please.
Clearly, in engaging with this issue, the legislation could have taken one of 2 approaches. One, as is in the bill that we have before us, to have a tight definition of what's caught. The alternative approach could have been to lay out what the objectives are and to have guidance that led you more into a judgmental situation where you looked at the case and decided whether there was an issue. I wonder what your views would be of the relative merits and disadvantages of these 2 approaches to deciding when the law applies.
I would consider that each application or complaint that is received would need to be dealt with in its own individual merits. But I did note earlier in from your colleague Anne McTaggart, MSP, that there was she made mention of nuisance vegetation, and I know that's something that our colleagues at Scott Hedge have been actively campaigning for over a long number of years. But I think the definition within the High Hedges Scotland Bill needs to be what it says. It needs to relate to hedges, as my colleague Eric has already stated. A hedge, in a horticultural sense, would be something that would be planted individual plants at no more than a metre apart. Sometimes 4 or 5 plants to the metre, sometimes up to 9 plants if it's in a staggered row, and something that would be intended to form as a hedge or a screen. And I notice the word screen has not been utilised in the text in the Act. Therefore, it's quite specific that it's hedges and no other nuisance vegetation. Statute law, precedents and court cases before that, and common law rights already exist with regard to that.
Mr. Hamilton, do you want to come in on that?
No, that's covered.
Okay.
Can I,
Stuart,
can I just, in the light of the evidence that we had from the Isle of Man, where they're working on a different definitional basis, there was a much higher suggestive frequency of cases. The 6 or 7 a year in a parish with 2,000 electors seemed to be more than we perhaps had expected. Given the relatively tight and quite specific definition to which we're currently working, and indeed any of the options perhaps to open it up still leave it quite tight and specific, have you any sense, and it would have to be a judgment this because I don't think you can factually answer it, as to what you would expect the number of cases to be in a typical Scottish authority, or if there is such an animal, or indeed in Scotland as a whole. And I make the distinction between, if you like, the backlog, which might be dealt with in the first year or couple of years, and what the steady state might be once you've dealt with the backlog, because I recognise they're two distinct things.
Yeah, if you just stick it to hedges, I can deal with that comfortably. If you introduce trees, I'll be taking early retirement.
But what are the numbers, if I may?
I would think in my urban environment, once all the hoo-has died down, I'm looking at maybe 10 cases a year, perhaps less.
In Dundee?
Yeah.
Mr. Patterson, do you want to come in there?
Yes, well, we are. I mean, the mere fact that an Act existed in England and Wales, and indeed in Isle of Man from a later period, has given some members of the public in Clackmannanshire the opinion that a high hedges bill exists in Scotland. I would think it's fair to say that I get maybe 6 to 8 inquiries a year. A couple of them are repeat inquiries, and 3 current ones are just waiting on the High Hedges Scotland bill actually being enacted before they consider their individual situations further. I think what will happen, as Eric has suggested, is that once it is enacted, there will be an initial flurry of complaints, and that's already been anticipated in the background papers to the Act. We would hope that we would deal with that at the inquiry stage, and that the actual need for a notice would be few, but it's difficult to ascertain that because it's a new beast to us in Scotland.
Do you have any comment, Mr. Phillips?
I don't have any numbers based on local authority areas. I'm aware within the last 2 years, I'm aware of 6 cases that if there was to be a piece of legislation with a broader definition would probably go to that legislation. That's on 4 separate properties, individual properties rather than areas. And all of those would involve individual or deciduous trees. One area in particular there, I would expect that the number of cases there to snowball if the definition was to be broadened to include deciduous trees.
Thank you very much. John Wilson, please.
Thank you, Convener. Good morning. Is taking on the issue about trees, if trees were included in this Act. Mr. Hamilton, you said your option would be to take early retirement. The issue for us is to, because there may be, and there is a demand to try and widen the scope of this bill to include deciduous trees. And a note from the submission made by the tree officers in almost the last paragraph, where you actually make reference to trees that have been there longer than the properties, or longer than a conservatory or a sunroom, how many complaints do you think we would, or how many complaints would emanate from people who then decide to build a conservatory or a sunroom and then decide that the tree next door that's been there for 50 or 100 years is now a barrier to their enjoyment of light in their sun lounge or conservatory?
Couldn't put that into numbers, it'd be too many. We'd be inundated. My switchboard would be lit up, my emails would be lit up.
But you think it would be a substantial number of complaints would emanate from that if we extended the definition? The other issue in terms of definition in the bill, we actually talk about a hedge as forms anything over 2 metres high. Now, in the evidence session we heard last week and the earlier evidence session from the Isle of Man, we were given examples where hedges are more than 2 metres high, but local discretion or issues have raised, they say that it may not be appropriate to set it at a 2 metre height because there may be issues of privacy or other issues in terms of a hedge sitting on a slope overlooking a particular garden or house. Do you think 2 metres is the appropriate height that we should be setting this at, or should there be more discretion within the bill for the heights of hedges that would form a barrier to light?
Answer that one. I think, as was described in the Isle of Man case, I think the topography of the land in which the vegetation is growing bears a great deal of weighting on how that would be judged. And again, as I suggested earlier, I think each case has to be judged on its own merit. And obviously there'll be some calculation provided that we can be guided by to take the matter further.
Mr. Phillips, have you any response to that question?
I would support what's just been said there.
Right. Now we move on to the barrier to light issue, and the evidence from Isle of Man was the only measure that they use is a 6-foot pole. Do you think it would be appropriate or would be necessary for more technical equipment to be used to determine and define what an appropriate measure is for someone to make a complaint that there was a barrier to light in their amenity or garden?
I can see or recollect most of my complaints come from hedges that's been allowed to grow when they're only 2 or 3 metres from windows or buildings. You do get software cover for shade, which could be applied if the hedges are further away and it's just garden ground they're concerned about. If it's a high hedge, it's only 2 or 3 metres from a property, a pole would do, I think.
That's interesting, Mr Hamilton, because you said 2 or 3 metres from a property, but depending how that property lies in relation to sunlight or daylight, it may be that the hedge actually sits to, say, the west of the property. Would it be appropriate in those circumstances to actually then for someone to make a complaint about barrier to light when the main part of the building faces south, but the only hedge that divides is on the west side, and if we know how the sun rises and sets, then the only time that would really be a barrier to light would potentially be late evening.
Yes, and that is a problem because everybody works during the day and they come home expecting to get sunlight in the garden or your patio is all shaded by the hedge. From the point of view of trees, this happens, but a hedge could be managed and controlled. Let's say that there is software available to apply to give shades and how far any hedge will grow, which can be applied.
We were in the earlier session and Paul Parker from the Isle of Man, the community warden, clearly indicated that they carry out extensive surveys throughout the year to measure the barrier to light and the impact of the particular hedges or trees that are growing that are being complained about. Do you think the local authorities in Scotland would have to carry out the same due diligence to ensure that there was justifiable reason for either lopping a hedge or a tree because of the issue of barrier to light, without carrying out that due diligence and monitoring for at least 12 months the barrier to light issue?
I think the case that our colleague Paul in the Isle of Man referred to was the case that went to court. I think it was that particular case that was monitored over the full year to give judgment on the different seasons of the year on that. I would doubt very much if it's necessary to do that in all of the cases. If there is, this hedge height and light loss that was issued by the OPDM for the England and Wales legislation, something like that is available in Scotland and it's specific to hedges, then I think it should be relatively a straightforward matter to make a calculation and a judgment.
But just to clarify that, Mr. Parson, that would only, in your opinion, that would only be specific to hedges. It wouldn't be specific to trees or other vegetation.
No, as I stated earlier, I think deciduous trees have never been the subject of precedents or court cases with regard to that have been successful with regard to loss of light. The circumstances surrounding a case being successful in that regard would relate to a property being totally excluded from light for the entire year for a significant number of years before a civil action would be even considered. And I would strongly suggest that the same would apply to individual deciduous and groups of trees, and they should be excluded from the Act.
Thank witnesses for the evidence.
Thank you. I have Anne McTaggart and Stuart McMillan on my list. I wonder if you would mind if I let Mark in, because he does have to go to the Finance Committee. Do you mind? Mark MacDonald.
Thank you, Convener, and to the committee for your forbearance. A note from your written evidence, Mr Hamilton, you make a suggestion that there should be a standard fee across all Scottish local authorities. Is it your view, or indeed the view of your organisation, that the costs borne by local authorities would be of a similar or equal value?
I think it'd be easier applied if there was a one price for all. I don't know how everybody else gets paid. Most local authority officers are on the same salary. It's when you get lawyers and everybody else involved that the price goes up.
I wonder if you have a view on that from the tree officers group, Mr Patterson.
Yes, I think the fee will vary depending very much on the authority that's taking the case and the amount of different departments, as Eric has said, legal advice and others. I mean, from our point of view at Clackmannanshire, from the initial meeting I've had with my service manager, she takes the view that we should be dealing with this very much like a planning application and apply the same fee. And that may be the way that Clacks will take this forward.
And I wonder if the panel's view would be that while the definition that is here may not deal with all of the cases that Scott Hedge have raised, whether you feel it would address the majority of cases that exist in your local authority area in relation to high hedge or indeed vegetation-related matters.
If the definition remains as a hedge, I think it will.
If it remains the definition as a hedge and doesn't include trees, it'll do what it says in the tin.
I have no further questions at this stage, Convener.
Thank you.
So thank you for your time.
Anne McTaggart, please.
Convener, Mark's just asked the questions that I was going to ask about fees, so these are all covered.
Okay.
Thank you.
Stuart McMillan, please.
Thank you, Convener. Good morning, gentlemen. Mr Patterson, you just mentioned the word planning a few moments ago. You just mentioned, I know. But also with the evidence that we heard today from Isle of Man, when the question was posed regarding what came first, was it the tree, or was it the tree or the hedge or the house? And by the time we got to the end of the answer, it was suggested that it was around about a kind of 50-50 split. And certainly with some of the information we've heard from yourselves today, there has been that kind of debate as to what was there first. This question is not regarding this bill per se, Convener, but certainly in the wider kind of planning context. It certainly appears that this type of incident has not been considered in the past when planning applications are going forward to build new housing developments. So with that being the case, do you think in terms of kind of the wider planning legislation that we have, do you think it would be useful for when an application goes in that there should be some type of kind of condition or some type of kind of thought process or understanding in terms of kind of high hedges or whether it's deciduous trees or whatever, so that that hopefully we could try to plan out further down the line any such incidences actually taking place in the future.
Certainly where construction is concerned, which would possibly include an extension to a house and planning consent is required, BS 5837, the amended version, which is 2012, takes cognizance of trees in relation to the proposed development, and advice would be given on that to our development team in terms of how that should be processed.
That was just for an extension, am I correct? Or
no, that would be for any type of construction that you specifically mentioned, you know, a conservatory or something like that. Anything that required planning consent, if there are trees involved, there should be a consultation process whereby the tree officer would be asked to give advice to the development team on the relationship of the proposed building to the tree and whether there would be any adverse effects to the residents, the occupants, or indeed to the tree.
But what about if it was going to be a new development, a new housing development?
The same thing applies.
Same thing.
Yeah.
Right. Okay. That's helpful. Thank you.
Okay. Margaret Mitchell, please.
This is to Mr. Pattison. I notice in your written submission you refer to what I think could be described as an original intention of planting test. And you say that if a row of trees is a feature of the wider landscape or a garden or park, then it could be unreasonable to consider these as a hedge if the original intention was not to form a hedge but to form a row of trees. How feasible or even relevant is this really realistically?
Well, it is realistic, Margaret. I think what we'll have to take into account in a situation like that is what was said in the submission, is what was intended at the time of planting and how it's been managed. If you take, for example, Lawson cypress, which are often planted as a hedge, but very often also planted as ornamental trees because there's so many different variants of them. There's golden types, green types, blue types. And it hasn't been uncommon for large houses in estates that have then been had houses built around them, or indeed large houses such as Ballochcastle, for example, where cypress are a feature of the landscape in terms of a formal double row of cypress trees either side of a path leading to Ballochcastle. If then properties are built adjacent to that, and they become affected and they're captured under the legislation, as I said earlier, theoretically, if a notice had to be served on, or it was acceptable for a notice to be served in a situation like that, pruning these trees, if they're 100, 150 years old, would be to their severe detriment. It would damage them irreparably. And it's in situations like that where, again, each individual case has to be taken into account, firstly, to ascertain the precedents. Did these trees exist prior to the complainant making the complaint or moving into that property? And if so, there's an element of acceptance of that and the fact that trees also grow.
Isn't it the case, though, the example you cite, then there might be some documentation, there might be something written there as to why they were planted, but in the vast majority of cases, then it would be one person's word against the other. No, I didn't mean to form a hedge. But that, regardless of that, the fact of the matter is that it looks like a hedge and it's having the effect of a hedge. So just how relevant is the intention to plant if we're now faced with the situation that it's doing everything that a hedge does, whether that was the intention or not?
I think what you would find in almost all of the circumstances like that is that there would still be some tree shape to the plantation. There'd be little or no evidence of any trimming, and that would give the tree officer the opportunity to decide what the intention had been. And quite simply, by looking at if it was Glebe Terrace in Alloa, for example, which is a conservation area, the buildings there go back to the 19th century, and trees and hedges such as yew and holly and things like that that have been planted then when the houses became flatted, that's when you get different owners maintaining them differently, right? Either allowing them to continue as the original planter had intended, or some people would take it upon themselves to manage it as a trimmed hedge rather than individual trees. So there's lots of different individual circumstances that have to be judged on their own merit at the time.
So do you think this could be a blanket provision, or should it be tailored to certain circumstances?
As we've said earlier, I think the definition in the bill has to relate to hedges. A tree officer would know immediately if 2 or more trees in a row had been intended to be planted as a hedge. And a hedge is generally maintained at some stage in its existence, not necessarily by every occupant of the house if it changes ownership in subsequent years.
Forgive me, again, I don't see the relevance of the intention other than in maybe very specific circumstances for historic, cultural reasons, in which case it wouldn't be a blanket provision.
Yes, you're correct in that sense. Yeah.
Okay. John Wilson, please.
Can I just examine that further, Convener? Now, the issue or the example Mr. Patterson gave was row of cypress trees that were planted 100 to 150 years ago have now grown. There was no adjacent properties to that planting. In 2012, a developer comes along, then decides to build houses next to that avenue of cypress. Is your fear that whoever moves into those properties once that development is completed could then, under the current bill as proposed, then say, I want those cypress trees cut down to 2 metres high because they're a barrier to light to the house that I've just moved into that's just been built?
The developer, local authority or the person moving into the house should take that into account before they buy it or build it.
If only common sense applied across the board. I gave an example the other week of someone who moved next door to a playground and then campaigned for the removal of the playground. I think that Mr. Wilson's point is extremely relevant here, and I think that we should forget about what common sense would normally apply and deal with the question as is.
As I said, Convener, my concern is that because of the urban growth areas that are currently taking place, and we heard an example at the last week's evidence session from Scottish Wildlife Trust, who gave an example of a development that had been built next to Woodland Glen, and somebody had planted 30, 40 years ago larch at the edge of that Woodland Glen. A development then went up, and then the new occupiers of the houses in that development then complained about the larch being too high, and then the Scottish Woodlands Trust had to then step in and take remedial action. But that was because when the trees were planted, there was no properties next to that. And as the Convener says, if only common sense were to apply. The problem is as this bill is written and as this bill will be interpreted, we have to try and assess whether or not there will be protection guaranteed to trees or hedges, whether it be cypress or otherwise, are protected despite any development they may take place or any, as you in the report submitted to the committee, sun lounge or conservatory is then as an afterthought is built onto that property. And it's really trying to examine that and what protection would you like to see for particularly an avenue of cypress that has been planted and has been established over a long period of time, long before any developer thought about building houses.
I think I've already covered this, but I would certainly think that, the row of cypress situation would have some impact on the landscape feature that it provides within that particular building or estate, if you like, and then properties are built next to it. You also alluded to reducing them to 2 metres in height. The bill, as it stands just now, seeks to suggest that no action will be taken on any hedges or 2 trees or more that are growing in a row that, unless it exceeds 2 metres in height. But what it doesn't do is give a height or a guidance at this stage as to what the calculation that would have to be provided with would then give a determination on what it should be reduced to. And that then goes back to what I previously stated, that if a 30-foot cypress tree or row of cypress trees needs to be reduced by 2/3, they are no longer viable. And therefore I would take the view, they'll be brown at the top, snow would gather on it, and eventually they would go into decline. You take the view that if the Act applied to a situation like that, it would be better removed. Because what you'd be left with is something that is very unsightly and unviable.
Mr. Patterson, the reason why 2 metres high is in the current bill under Section 1 and 1B. It actually refers to this Act applies in relation to a hedge referred to in this Act as a high hedge, which in Section B rises to a height of more than 2 metres above ground level. So that I'm assuming that anybody interpreted, or the interpretation of this bill could be, if you have a hedge that's higher than 2 metres high, then that hedge should be brought down, or could potentially be argued that hedge should be brought down to 2 metres high.
That would be the general opinion of the public, but it's not how it works in reality. It's not how it works in England and Wales. It's reduced by a height that allows, if it's a hedge, an evergreen hedge, that allows the optimum amount of light and retain the hedge.
Mr. Hamilton was desperate to come in there, Mr. Wilson.
It was just that the scenario was an avenue of mature lost and cypress trees. I wouldn't class that as a hedge. If the trees have been planted significantly apart, 3, 4, 5, 6 metres apart, and they matured, I wouldn't class that as a hedge. That's an avenue. That's an avenue of trees.
Referring to Section A in the same Section 1, which is formed wholly or mainly by a row of 2 or more evergreen or semi-evergreen trees or shrubs. The difficulty here quite clearly seems to be in the definition and the interpretation of the definition that we're actually trying to look at in this bill. And clearly, Mr. Parson, you said the general intention or the general purpose of the bill and the public's interpretation of the bill. Now, lawyers will make a lot of money out of interpreting legislation. My fear is that the cost, and we heard some costs earlier from the Isle of Man, but the cost of a local authority defending its decision not to take action against, in favour of a complainant who said that the hedge is more than 2 metres high, therefore causing a barrier to light. Local authority says, but it's not causing a barrier to light because we've decided the hedge height could be anything up to 5 metres high, for example. I'm not saying that they will do that, but say 5 metres high, where the complainant says, no, I think that severe detriment to my property causes a barrier to light and I want the local authority to take appropriate action. Then you end up finding that local authorities end up in the court of session trying to defend the decision that was taken for all best intents and purposes based on their knowledge and understanding of what would form a barrier to light.
My understanding of Section 1 is quite clear that the hedge or 2 or more trees growing closely together, which is something that we would seek that latter part to have removed because it could relate to a couple of mature yew trees that are 3,000 years old, right? You then reduce that to 2 metres high, as you're suggesting, you no longer have individual looking yew trees. But in no way suggests that the resultant height of the hedge should be 2 metres. It merely expresses that action will not be taken unless the hedge is more than 2 metres high.
as I said, convener, it will be down to interpretation and what the public's interpretation of this, as opposed to officers, local government officers in the field, will be an interesting development if this bill goes ahead. And I thank the witnesses for their evidence.
Margaret Mitchell, please.
Mr. Phillips, I notice in your written submission you say that yew hedges should be specifically excluded. I wonder if you'd like to put on the record why you consider that the case.
Well, the majority of cases where I come across yew hedges or avenues of yews that have grown together, they tend to form part of a historical landscape, either churchyards being the prime example, also policy grounds for old houses. So that's one reason that I would want extra protection for that type of hedge or row of trees. The other is that yew is generally a fairly slow-growing species. So the way I interpret this bill is it seems to be intending to capture the kind of neighbourly disputes where people have planted Leylandii as a weapon, as I believe Scott Hedge described it. And yew just wouldn't be used for that purpose. It wouldn't grow fast enough to cause problems within that kind of time frame.
And if there was an odd example, a very odd example, would it be sufficient to cover in the legislation a presumption in favour of yew hedges not being included, but still allow for maybe a very random case where it could be a problem and not acceptable?
I think I would be content if there was a written presumption in the bill against action being taken on yew hedges.
Can I turn to Mr. Hamilton's submission? Very concise indeed. I like concise, I have to say. Number 6, are there any aspects of the systems used in other jurisdictions which should be included within this bill? An emphatic no there from you. If we were to extend this bill, are there any aspects of the system from other jurisdictions that you think that we should definitely leave out of the bill? Mr. Hamilton first, please.
I think we should leave out TPOs, any reference to TPOs, and leave TPOs on their own. And take it, just leave it to high hedges.
Mr. Patterson, do you have an opinion on that?
Absolutely concur.
And Mr. Phillips?
I would agree, yes.
Thank you very much. Can I thank you very much, gentlemen, for your evidence today. Thanks a lot for your time. I suspend for 5 minutes and then we move into private.